All right. Hello, everyone. How's it going? This is Immigration Attorney Momita. I'm coming to you live to talk to you about immigration and to see the questions that you may have on your mind. Thank you so much for joining me on this beautiful day. My name is Momita Rahman. For those of you who don't know me, I am an immigration attorney, and I have been practicing immigration law for almost 14 years. My 14-year anniversary of being admitted to the bar to practice law is coming up next month in March. So thank you so much for joining me today. If you are an immigrant who has a question about your case or you're concerned about your future, please go ahead and pop me your question in the box below, and I'll do my best to answer as many questions live in this time that I have today. And if you are looking for a case evaluation, call us at 212-248-7907. All right. The topic that I want to start off with today, because it is something that is really important, is did you used to have a 2-year residency card? Did you used to have a 2-year green card and it expired and you no longer know what to do because you are no longer with your spouse, you've been divorced, and you are out of status? Well, this is something that's really important because many of you out there who used to have a green card through your marriage, who are no longer with your spouse, think that all hope has been lost and there's nothing that you can do once your marriage has ended and your 2-year green card has expired. I am going to get into this very, very serious topic in just a second, but do me a favor, write my number down at 212-248-7907. All right, so are you a conditional resident, which means you have a 2-year green card and you got your green card through your marriage to a U.S. citizen, but you are no longer with your spouse? Maybe you separated, maybe you divorced, maybe you were suffering a lot in your marriage and your spouse wouldn't actually help you try to remove your conditions, or maybe you did already file this I-751 application to remove your conditions and maybe things didn't go as expected. You got an interview, your spouse wouldn't show up, or you had a bad interview and they told you that you did not have sufficient evidence to prove a bona fide marriage. And now your card has expired, your marriage is over, and you are still here in the United States wondering what you can do to fix your situation. Well, would you be surprised to know that you may still be able to get your 10-year green card, even if that marriage is no longer, in existence, maybe even if you have no longer spoken to your spouse in the past 5 or 10 years. It does not matter how long your card has been expired for, you may still be able to apply to get a 10-year green card and move on to U.S. citizenship and be fully secure in the United States. And the reason for this is that when your marriage does not work out because, number one, you are either suffering in your marriage because your husband or your wife was controlling you, they're being manipulative, sometimes they hurt you physically or they just hurt you emotionally all the time, or you get divorced and the marriage did not work out, you can actually apply for something called a waiver of the joint residency requirement. And there are many benefits to doing this. Number one, it allows you to apply by yourself, even if you cannot apply with your spouse any longer. And number two, there is literally no deadline. So no matter how long ago your 2-year residency card may have expired, you still have the power and the ability to file that application one more time, regardless of how long you've been out of status. So if you're in that situation where you originally got your green card through your marriage to a U.S. citizen, but things did not work out, you let your card expire and you're just not sure what to do or where to turn to right now, please call us at 212-248-7907 to see if we can help you move forward in your immigration journey and get you back on your feet through this way, all right? And one more thing to understand is a lot of people, you may have had your I-751 denied previously by a different immigration officer because you didn't have enough evidence or you had a really bad interview, your husband or your wife didn't show up to the interview. And can you still fix this way even if you already filed a previously filed I-751? And the answer is yes, you can. You can still file a new I-751 even if it was previously denied. Now, can you still file an I-751 if your previous application got denied and you ended up going to court in front of an immigration judge? Yes, you can. So the bottom line is that there are actually many, many situations through which even if your 2-year residency card expired, you can still do something today. So call us at 212-248-7907. Chingigante, I'm going to pin my number here on Instagram so you guys have it nice and clear. Give me just 1 second while I pin this. All right. So the bottom line is, again, if you are in a marriage to a United States citizen where your marriage is not going well, let's talk about if you don't have a green card at all. Let's just say that you entered the country illegally. You've never had papers. You've never had a social security number. You've never had any opportunity to fix your papers because your spouse was the one who is supposed to help you, but for one reason or another, it's not working out, right? Like it's either your marriage is not working out or either you're not moving anywhere in your green card application because all of the documents are in the control of your spouse, right? What are your options to get that green card in the first place? And the answer is that if you are having problems in your marriage, you may be able to self-petition for a green card instead. Now, there are some limitations, but believe it or not, the limitations are not as many as you think. And for those of our clients who may not be eligible through this manner, we still try to screen for as many types of cases as possible. And when I say screen, what it really means is we ask questions so that no stone is left unturned for our clients. We do not like to give up on our clients. We do not like to not find a solution for them, okay? So again, call us at 212-248-7907. All right, I'm gonna turn my attention to all the comments in the boxes below. Please understand that I am live streaming on 4 different platforms at the same time: TikTok, Instagram, Facebook, and YouTube. I'm trying to do my best to answer, to reach as many immigrants as possible throughout the United States. So let's go ahead and start right now. And if you want to make it easier, come follow me on Instagram and ask me the questions there because that's where I'll answer most of the questions. Tina's asking, can I remove my conditional green card even on my own, even if I'm still married to my U.S. spouse, but we're living separate due to the circumstances we are in court? Tina, absolutely 100%. You can still file for your green card by yourself, even if you're still married, even if you're living together, or even if you're separated, even if you have the divorce process pending right now. You don't have to wait for that divorce to finish. Call us, Tina, 212-248-7907. Now, I don't want to say that every marriage is like this because it's certainly not the case, but I do, in my line of work, because I have been working with hundreds, and I'm just going to say it's probably thousands of clients by this point. When you are undocumented and you're in a position of having to rely on a U.S. citizen who happens to be your spouse to do your papers or to fix your status or to continue your case, the problem becomes if you have problems in your marriage and you get into fights, and then your spouse, if they start using your case or the fact that they're helping you or the fact that they've helped bring you to this country as a way of making you feel guilty, as a way of making you feel bad, or as a way of telling you that they're not going to help you any longer because you don't deserve it for whatever reason. When that happens, that is the true definition of power and control being abused in your marriage. And as an immigrant, you do have certain options that are available to you. And that is why I am here in front of you today, is to let you know that these options exist so you don't stay trapped in a situation where you feel like you have no more control in your own life, okay? So Tina, call us at 212-248-7907. Imi is asking, my asylum case is pending. Can I travel to another country with a travel document? Not while your asylum is pending. Privilege photo, I got approved for an I-130 on April. How much longer for action? Privilege, I don't know. It always depends on your preference category. Pragnesh, you're asking a question about an EB3 visa. It may be possible, but I don't work in these sorts of cases, so I don't actually have the answer for you. But we do have lots of. I have some good friends who work in this area of law for business visas, employment-based visas. So if you call our office, we'll give you a referral. Millie Crump, how long does a military PIP take to get approved? Millie Crump, that's really, really good. And I'm actually going to explain to you guys also what military Parole in place is, or military PIP, as it's also known for in short. So military PIP, I'm going to say it can take like 1 to 3 years because it really depends, Millie, on what the local office is doing, because military PIP, when you make that application, it's a very local application, and it has to be decided by your particular field office. So number one, it's going to depend on how long they're taking to get through specific cases. Number two, it's also going to depend on what priority they place on it. And honestly, most of the immigration offices are placing their priority on processing citizenship cases these days. Also, they're placing a priority on processing applications for immediate relatives. And an immediate relative is basically the spouse or the parent or the minor child of a US citizen. Everybody else is not an immediate relative. They're considered a preference category relative. And, an application like military PIP, it's just one of those kind of like nebulous areas where there's not a clearly defined set timeline. But once that's approved, then you still have to go through the process of your I-485 if you're doing that for the green card itself. So that you have to tack on some additional time for that, Millie. I hope that helps. Nita, do you help with work permit process and also help to look for a job? Nita, okay, I'm going to answer this question real quickly because I've been getting a lot of messages on social media asking me to help people find them a job. And I appreciate the situation that people are in, but I don't help people find jobs. I only help do certain immigration cases. And even at that, I don't do every single type of immigration case because I do have special particular niches in humanitarian immigration cases. So Nita, I do help with getting people their work permits, but it depends on how you're trying to get that work permit. I don't help people get work permits through job applications. And for help in finding a job, you'll have to contact somebody else. And I also want to explain to you guys what military parole in place is. If you're the spouse or the parent of somebody who has served in the military or is currently serving, and you have an illegal entry into the United States, if you can get military parole in place, then that will actually allow you to fix your status inside the United States and not have to leave the U.S. So it's a big benefit for the moms and dads who have come in without permission into the United States. But the one place it wouldn't work really is if you have something called a permanent bar, because the permanent bar is a different sort of problem that cannot be fixed through the military parole in place. How much is a consult from V? Our consult is $150. And also just another reminder that the only way to reach our office, the only phone number that we have is 212-248-7907. There are a lot of scammers out there. I'm not on Telegram. Please don't send money to anybody through Telegram or WhatsApp or a wire transfer. That is not how we conduct business, okay? All right. My spouse applied for an I-130 and he's a green card holder. How long will this take? From Shimona, it would probably say that probably take a couple of years at this point because of the preference category relative. I'm waiting from Adri Herrera. I'm waiting for the interview for 2 years. Spouse is not in the picture. What to do from Adri? Adri Herrera, this is a very, very good question. If you have already started your process with your spouse, whatever the process is, right? It's an I-130 or it's a waiver or a perdón, or you do the I-485 and you're waiting for an interview here and it's been pending for a long time because, as we know, immigration takes forever to process so many cases, but your spouse is no longer in the picture. Do you have any options left? And Adri, the answer is yes, you may still have options. You may be able to convert your case into something called a self-petition. You may qualify for other types of cases as well. And the only way for us to find out what your possibilities are is for you to call us so we could do a case evaluation for you. And our phone number is 212-248-7907. We do have a case fee for that, which is $150 for the evaluation. But if we can't find an option for you, or if you call us for something that we're not working on right now, we would give you a refund of that evaluation fee. All right. On YouTube, hello, YouTube, and Facebook, hello. Can an M1 visa apply for marriage-based green card adjustment of status? From Manu. Manu, I believe so, but I'm not. You might need a waiver of some sort, but I think you should be fine. But I can't really say for sure right now. Dear attorney, do you have to have Do you have to have witness letters attached with your I-360 for your approval, or have you had any VAWAs approved without witness letters from MK? Great question, MK. So 100%, you do not need to have any witness letters for your case. Actually, in fact, immigration considers your witness letters to be self-serving. You know, like they don't give it 100% of evidentiary weight when you give a witness letter from someone that claims to know about you. So what we do is we only use witness letters in our case when there is nothing else to give, right? When there is no other evidence, our client has access to like not even one shred of document. That's when we give a witness affidavit. And MK, absolutely, we've had tons of VAWA cases approved without any witness letters. But of course, if you have witness letters, then we like to use it. But not all witness letters are created equal. In fact, sometimes, it's very obvious, it's very obvious, like if we ask you, one of the reasons why we don't really ask for witness letters from our clients anymore is because we know how it works. Like, I know how it is, right? Like if you're going to ask somebody to write a letter in your support, sometimes they'll say to you, oh, go ahead and write it for me and I'll sign whatever you write, right? Or they'll ask you to help them write it. And sometimes you as the applicant, you might draft everything and then just have your friend sign it. And what I see in those cases is that, sometimes the client might give us like 5 letters that look the same and they look like they're typed in the same computer. And that's a no-go. That just, that's going to stick out like a sore thumb to immigration. And they're going to immediately be like, what the heck? It's like, what the heck? So only give a witness letter if it is actually written by your witness in their own words, in their own language, from their own perspective. If you are going to use witness letters in your case, please do not write it yourself, or please do not type it all up on the same computer. Those things is just common sense, guys. You don't want to cast doubt upon your case, and something like that would 100% cast doubt upon your case. Okay. All right. PT Ravi, a friend is applying for VAWA. Her kids are born here. Can she apply for government help and food stamps? From PT Ravi. PT Ravi, yes. When you apply for VAWA, you are not subject to the public charge rules. So you can apply for as many benefits as you want. It will not count against you when you do your green card. I received my social security card today, but not my EAD. Is that normal from Kizzy? Kizzy, yeah, sometimes one comes before the other. Normally the social security card is the one that arrives really late. But yeah, it does happen that way. Can a DACA recipient over 21 with permanent resident parents adjust status? How long does it take? From Mota, no. Well, sorry, I take it back. So you may be able to adjust by doing a waiver, probably, because if you're in DACA status, it depends on what age you were when you got your DACA and whether you have unlawful presence. Also, in order to adjust your status inside the United States, you need to have a current status, and a DACA is not a status. It's just a deferred action. So you can have your parents petition you. It takes, like 10 to 15 years. But most likely you would have to leave the United States for processing, and you would require a waiver for unlawful presence beforehand, which you can use your parents as your qualifying relative for that. Sam, I don't know why you're saying don't apply for VAWA. I don't know who you are. I do this for lots of clients who have found life-changing results through VAWA, and it is 100% legitimate as long as you're working, your story is real, and you're working with a lawyer who knows what they're doing, like we do. What happens if a kid of an LPR got married while waiting his visa? LPR then becomes citizen. From Kelly Dookie. Kelly Dookie, if the application was filed as a child, unmarried child, then getting married would actually cause problems for that status. Does traffic ticket count as an arrest in regard to citizenship? From FemRight. FemRight, it counts as a citation or a charge or offense. So a very important question that I want everyone here to be aware of when you're applying for anything in immigration is in most applications, you have the question, have you ever been cited, arrested, detained, or charged for any crime or offense, right? Cited, arrested, charged, or detained. There's 5 different ways. Basically, if you have ever had any encounter with law enforcement, that will count as either a citation or a detention or a charge or an offense for criminal law. Salam, thank you for the rose and the little heart thing. So answer wisely, even if it means you have to answer yes to just a traffic ticket, that could possibly count. And you want to be seen as being more upfront and trying to be overly honest than trying to hide something in immigration. Starfire Angel and Melissa, thank you for the roses. I appreciate that very, very much. All right, let's see what other applications I have. Melissa, let me see if you asked a question. Let me try to get to that. What percent of VAWA cases are approved? Melissa, I think I found your question. What percentage of VAWA cases are approved? Melissa, I don't have that information exactly. Overall, I don't know exactly what the total percentage of VAWA cases are that get approved. It's very hard to tell also because the processing timeline for VAWA is very long. It's like 3 years long average. So it's hard to see like overall what the trend is. But what I can tell you is that from my office, the cases that I've worked on, I have had nearly 100% of all of my VAWA cases approved. This is not a lie. I have had nearly 100% of my I-360 VAWA applications for parents and for children and for spouses approved. The one case that we recently received a denial for somebody who, a client of ours who didn't realize that he was not divorced properly from his prior marriage. And this is actually a problem for my Nigerian clients. I'm sorry to say, guys, if you are from Nigeria or anywhere else, if you are from any country other than the US and you have been married more than once, it is critically important that you make sure that your first marriage was properly terminated before you marry your US citizen spouse. Because if your first marriage is not properly terminated, then immigration will deny your case later if it's based upon marriage. So that's one. And for sure, VAWA cases are, a lot of lawyers say that VAWA cases are hard. I don't think that they're actually hard when you understand what the basic concept is. The basic concept of VAWA is just, are you an undocumented person? Are you an immigrant married to somebody who is suffering any amount of emotional abuse, or do you have you had a loss of control in your life because of your spouse? And if you are a parent, now let me turn my attention right now to parents, because I get this question a lot. I know I've been informed by my team that a lot of parents are asking, right? And if you have a mom or dad who's undocumented, who's been here for 20 to 30 years, and they entered without permission and they're wondering what they can do. They've been told by other lawyers that the only way for them to fix is if their kids go to the military, or maybe they've been told that they cannot fix because they have the permanent bar. Well, VAWA is sometimes a solution through that. Now, VAWA, what I want you to think about is this. Do you have siblings, where that your siblings, like you have like that one brother or that one sister who is a problem, right? They are the classic hijo rebelde, right? They scream, they yell, they curse out your parents, they throw fits, they run away, they hit up your parents for money all the time and make them feel guilty. Maybe you have heard your siblings call your parents like really bad names, right? Like maybe you've even heard them, I don't even want to say these curses out loud, but maybe you have even heard your sibling tell your parents, to go back to their country, and why do they bring them here, and et cetera, et cetera. Well, a lot of these things are actually considered to be emotionally abusive actions, and they can be grounds to file for a self-petition by your parents. So that is one way that we help parents who have been here for a long time, who have an illegal entry, help them get their green cards that way. Now, if your parents have the permanent bar, what we like to look at instead are for cases of T visas and U visas as well. But the T visa is something that is being processed even faster than VAWA right now, and I like this a lot. And a T visa is much more commonly occurring in our community than we think, because almost everyone here has, if you're undocumented, has worked for somebody where the employer has been racist or abusive and exploitative. And if that your parent or your aunt or your friend, somebody has worked for an employer, or you've witnessed, in your workplace, your employer, cursing out your, the staff who's immigrants, or treating them worse, not paying them properly, having them do dangerous things. These are ways for us to get a T visa for clients who are undocumented, who have the permanent bar, and etc. So the T visa is taking about 2 years less than 2 years to process in total, and you get a work permit at the end. And then we can apply for a green card after 3 years of holding T visa status. So all in all, it's a good way to get to citizenship through a T visa if you have the permanent bar and you've been here for a long time. All right, lots of questions. Let's just see. Kizzy, thank you, Kizzy. Let me see if I can find your question if you have a question. Oh my God, Cher, sweetie. The firm staff is literally the best. Everyone is really nice, especially Diego. Oh my God, Cher, are you talking about Diego Fu or Diego Navarrete? I'm going to go ahead and let him know. Tishi, thank you for the follow. Do I need a U.S. police report or only antecedentes penales in Ciudad Juárez desde Rubio? Rubio, okay, si tiene un cargo criminal, necesita los reportes, pero también necesita el antecedente penal en su caso cuando teniendo una entrevista en Ciudad Juárez. Pero si nunca tenía un cargo criminal, no necesita un reporte criminal, pero todo depende en su caso. Okay. Omar is asking, my girlfriend needs to fly to Peru because her mom is sick. She filed for asylum and was going to receive her social and work permit. Is there a way for her to come back? From Omar. Omar, the bad news is, and this is for my asylum people who are watching right now, because I have this question more than once. If you have filed for asylum, you cannot leave the country until your asylum is approved and you have your refugee travel permit. If you leave the United States without your refugee travel permit, then your asylum, you won't be allowed back in, really. You would have to try to come back illegally. So Omar, the only thing that I could possibly recommend is to, I don't know, are you a U.S. citizen, Omar? Have you guys thought about getting married? Maybe that's one way, but your girlfriend would still need to go through a waiting period to get her travel document that way, okay? All right. Kesia, you're asking for my email address. I don't do my email address publicly because we would be flooded. We would be flooded with emails. But what I could say, Kesia, is that if you would like to send us an inquiry, you can actually go to our website. You can go to our website and send us a contact form message, and that'll come directly to our official inbox. Sabi saying hello. Does eviction affect your marriage-based green card? From Jack. Jack, no, not that I know of. Alicia, how does a previous DUI charge affect a VAWA application? Would it be better for him to wait for his abusive spouse to file the marriage-based green card, or can he still file for VAWA? From Alicia. Alicia, that is a good question. Can a DUI charge affect a VAWA case? And the answer is probably not. Now, the reason for that is going to depend on a few things. But number one, just 1 or 2 DUIs is not usually a problem. But it also depends on what happened with your DUI. If you actually seriously harmed somebody because of your DUI, then that would be something that's aggravated and that can affect your case. But in general, a DUI is just a DUI. It's not considered, a crime involving moral turpitude. It's not usually an aggravated felony. And a DUI usually does not affect most immigration cases. However, if you have a lot of DUIs and they're very recent in time, then that can be a problem because it might show that you have an alcohol problem. And in particular about your question, if you're worried about a DUI charge and whether you should not file for VAWA and you should do a marriage-based green card instead, the answer is, in my opinion, if you are in a situation where your spouse has been abusive, they've been controlling, they tell you one day they're going to apply for your case, and 2 days later, when they're angry at you, they tell you that they're going to deport you. Just file for VAWA. Don't live through that. We get a lot of questions. we get a lot of calls from people who are not clients yet, who are already in the middle of their process with their spouse, and then they decide not to start the case with us because they want to see what's going to happen and where the case with their spouse is going to go. They want to hold on to hope. But the reality is that when you try to hold on to hope in a case where your spouse has already demonstrated to you that they're gonna turn on you, it's called the cycle of abuse for a reason. It's literally, you keep going around and around in the same loop until you decide to break that cycle. And you can decide to take control of your own situation by breaking that cycle, just to do this case. Because when somebody is vindictive, when they turn on you, when they try to harm your case or they try to harm you, but then for like a period of time, they're really great and they say they'll do anything to help you. But then it just takes that one moment for them to change their mind the next time, right? And besides that, the fear and anxiety that you'll be living with, Alicia, to wait for the other shoe to drop, you don't deserve to live that way. And at the very least, when it's your own VAWA case, it's in your control. It's in your control, so you don't have to sweat about what's going to happen to your case. All right. So at the end of the day, it is your decision to make. I am an advocate for my clients to do whatever is best for them. I would never give anyone any shame or any pushback about not starting now or about not filing or getting back together with their spouse. That's not my business. My business is to make sure that you are happy. Okay. 212-248-7907. Arturo is asking, how long does it usually take to get an interview at Juarez? I'm active military duty. Arturo, if you're waiting for your immigrant visa interview, Kizzy, thank you for all those roses. If you're waiting for your interview in Juarez for an immigrant visa, these days it's taking anywhere from about a year to two years for that. So we are seeing a little bit of a speed up in that time. Melissa is asking, if we see a psychologist for VAWA, does the psychologist have to report past child abuse to parent? Melissa, no. As far as I know, psychologists are under a duty of confidentiality, and the only time that they would be required to report to go to police is if they believe. Actually, I'm not 100% sure about this, but I believe it has to do if they believe that their client is an active threat. A active threat of harm to others, then then they might report. But for something like that, for child abuse, they would not. And also, by the way, we don't require all of our clients to go to get a psychological evaluation for their cases because it's actually not always necessary. How recent should abuse be to file for VAWA? From Melissa. Melissa, there's no time limit. There's no deadline. Your abuse could have happened 10 years ago. The only time limit that we have to observe in a VAWA case is your actual date of divorce. So you have to be currently married to do a VAWA. You have to be currently married to a United States citizen to do your VAWA. Or if you got divorced, the divorce cannot be more than 2 years old. So if you got divorced 1 year ago, we can still do a VAWA. If you got divorced 1 year and 10 months ago, please call us ASAP because we're running out of time and we need time to file your case. And we hate being under pressure, but we will do it for you, okay? But if it's been 2 years and 1 month, then it's too late. So we have to be very, very careful about the deadline for that. Lots of questions, guys. Can an American citizen on disability petition for their spouse? Yes, they can, but you will need a joint financial sponsor if your disability income is not enough to meet the minimum financial threshold. How long does it take to make a decision on by USCIS on an I-360 from Vanny? Vanny, if you're filing for VAWA as a battered spouse, then it takes about 2.5 to 3 years. Shekhar is asking, how long does it take for an I-751 in Potomac Service Center? It's been 18 months and no update yet. Guys, would you believe that for the longest time, I thought it was pronounced Potomac? I'm terrible. All right. So Shekhar, I would say I-751s take about 23, 24 months. I want to bring my 2 daughters to the US. My wife is an American citizen. Do you take cases like this? From Z 3.0? Yes, I do. So call us 212-248-7907. Marissa, who is subject to the public charge rule? Persons filing for adjustment of status through immediate relative, so regular green card cases. So the only here, okay, let me say this more simply. The only times that you don't have to worry about the public charge rule is if you're applying for green card status as an asylum seeker, or as a trafficking victim, or a victim of violence, or as a VAWA applicant. Yeah, and I think SIJS as a special immigrant juvenile. So those are the only times when you don't have to worry about the public charge rule. Everybody else has to worry. I have a deportation and I applied for VAWA. What is my chance? From Sheetal Chaudhary. Sheetal, your chance for getting a green card, I'm sure, are great, because as long as your VAWA is good, we can take care of the deportation later. So we can call us 212-248-7907. Mandy Singh, watching from Queens. Thank you. Let's see this question. Chooks, I came on a K1 visa and my wife has refused to file my green card even after I paid for filing and attorney fees, and also made me pay $2,000 in mortgage on a house she bought after we got married, paid for all the bills, etc. So Chooks or George, call us 212-248-7907. Now, here's a situation that we do see commonly that I want to bring to your attention. If you were brought in as a fiance to the U.S. by your spouse, if your spouse doesn't help you get your green card, it puts you in a really bad spot, right? So we may be able to help you file for VAWA even if your U.S. spouse never actually did your papers and you came in on a fiance visa. But the time is going to run out if you got divorced. You only have about 2 years from that date. Now, a lot of times also, I hate to say it, but people can be also brought in as a fiance, and the person who petitions for you never marries you, and they basically make you into a servant in their home instead. And this actually happens quite a lot. And if that is your situation, then you may be eligible for the T visa, because you're brought into the U.S. basically under false pretenses of them wanting to marry you, and then you're basically treated as the person who has to do all the cooking and cleaning at home, do the work outside, and pay the bills. And that is most likely labor trafficking. Okay. Ranaji, I'm not going to give you the cost of my case or over here, but you have to do a case evaluation first. Simone is asking, for a T visa or U visa, do you need any type of document to prove as a witness? So Simone, a good question. I really like that question. So for a T visa, when you do a T visa, you do not need any, you really don't need that much documentation, but we do have to make an affirmative report to law enforcement, whether it is the Department of Labor or whether it is, the Department of Justice, or sometimes we do FBI reports, or sometimes we do a report to your local police station. We do have to report your trafficking to at least one law enforcement agency, but we don't need them to give us any certification saying that they believe your case or that they're going to take action on your case. However, when you do a U visa, one thing that is statutorily required in a U visa case is if you have been the victim of a crime, then you have to show that you cooperated with law enforcement, and law enforcement has to sign a certification, and we can only file your U visa application with that certification. So sometimes filing a U visa is not always just that easy just because you were the victim of a crime. We still have to get the law enforcement to give us a piece of paper back with their signature on it, and that can be a challenge in some situations. And sometimes if too much time has passed between the day that you suffered your crime and the day that we go to law enforcement for that certification, they may refuse to sign it too. Jaydeep, If I have an I-512L paper with my photo on it, do you think I can travel to my country from JDeep? JDeep depends on so many things. You know, if you have advanced parole, should you travel? Number one. I just want to clarify that if you have filed for asylum, but you're doing a marriage case now and you want to travel back to your country based upon the advanced parole you got, it's not going to look good, you know, because you've already filed an asylum from a country where you say you fear to go back to. So if you go back now just because you have advanced parole, it won't look good at all. Number two, if you have any criminal history, then I highly recommend you not tempt fate and travel and have to be inspected by CBP. I have a U visa expired. What do I need to do? From Carla. Carla, you may be able to apply to renew your U visa nunc pro tunc, or if you have some sort of extraordinary reason why you did not file right on time, you may be able to file. Can I do this? And I'll get like a heart in. Yes, I love that. All right. Can you get your F1 status back after you get a green card from Farhana? Probably not. But if you have a green card, I'm not too sure why you'd want it back. Nikhil, hello, thank you. Nikhil Rawat. I have a deportation and I applied for VAWA. What is my chance? My lawyer won't reopen my case with asylum. From Sheetal. Sheetal, you're going to be able to reopen your case after your VAWA is approved. That's what we're seeing in court. If you already have a deportation order that's been final in court and you're filing for VAWA or you're filing for a T visa, DHS is not agreeing to reopen those cases until your case is actually approved. So when you get your VAWA approved, we can go back to DHS and ask them to agree to reopen your case, or we can file a motion with the judge, with the court, asking them to reopen. Kevin, is it normal to wait over 3 years for an interview after approval? Not usually. 3 years sounds like a very, very long time. Kizzy, I know, Kizzy, I'm trying to find your question. Kizzy, can you post it one more time at the bottom? Kizzy, if you're still there, repost your question. Can you apply for VAWA if you have claimed you're a U.S. citizen? From Melissa. Melissa, that's a tricky one. But call us because we have to see what we can do and what it really means if you actually claimed, if you made a false claim, Melissa. Kizzy, I'm still looking for your question. If someone on TikTok sees Kizzy's question, can you repost it for me too? How long? What about if my husband cheated on me? Can I file for VAWA? Anna, you may be able to file for VAWA because most likely if your U.S. spouse has cheated on you, there's a lot more harmful things that probably happened. So call us 212-248-7907. Oh, Kizzy, I found your question. I received my social security card, but my EAD, is that normal? Kizzy, I think I answered this before, but it can be normal and it may not. So a lot of times when you file for your work permit, you can select the option to have Social Security Administration send you their social security card as well. And what will happen is, I guess, whatever process they go through inside of immigration, they send certain notifications to Social Security Administration saying that you've been approved for your work permit, and then Social Security does their own thing, right? And then they'll process your Social Security card, and they send it to you independent of immigration. So immigration has no idea what social does. Now, can it happen that you get your work permit before you get your Social Security card? Or can it happen that you get your social card before you get your work permit? And the answer is yes. However, Kizzy, what I would say is if it's been, for me, it's not normal to get the social before the work permit, because usually in my office, we get the work permit first before we get the social. And usually the social comes months after the work permit. And if you get your social but many months have passed and you haven't yet gotten your work permit, please look into it. Please look up your case online or call customer service to see what's happened. Sometimes you can get a tracking number for that. Things can get stolen in the mail, things can get lost in the mail. So I truly hope you can get your work permit in your hands pretty soon, Kizzy, okay? Jaime, if I'm in the military at 18, can my mom get parole in place? I believe so, but you couldn't file an I-130 for your mom until you're 21. I am from Bangladesh. Marv, thank you. Alda, I have a 2-year green card that I got after marrying a citizen spouse, and I applied for an I-130 for my 8-year-old child that is still in my home country for 17 months. What can I do to speed up the process? From Alda Elio. Alda, so if you have a 2-year green card and you filed an I-130, then your child is actually considered a preference category relative, and the category is not current at this time, and you cannot speed up that category. However, once your I-130 is approved, you can ask for expedites at that point. If you have been a T visa holder for 3 years and will be applying for a green card, how long does it take to get approved from star X Tiny? I believe they're taking about 1 year to 2 years for that green card to be approved. But I'm going to just err on the side of caution and say to expect at least 1.5 years for that green card. And obviously, you can always try to expedite if you have any emergency. My VAWA case is pending over 37 months. Should I contact USCIS? From Leo AZ? You can for sure contact them. I think that's not a bad idea. All right, YouTube and Facebook, turning back to you. Liliana is asking, how can you represent an immigration case if I am in California and you are established in New York? From Liliana Diaz. Liliana, great question. You asked this a while ago, like half an hour ago. If you're still here, Liliana, so here is how we work. I am based in New York and I represent clients all over the United States. And the reason for that is that in immigration law, immigration is considered a federal law. So I do not need to be admitted to each of the states of the United States to represent clients in immigration proceedings, nor, USCIS applications is not a proceeding. It's not a court. And I can file USCIS applications anywhere in the country for anyone, anywhere in the world. So I don't need permission for that. And whenever I'm required to, like if my client has a court hearing or an immigration interview that I have to be there in person for, I travel, or we get local attorneys to go if I cannot go. And also you have to understand that these days, the immigration courts themselves are doing a lot of web-based hearings. So I don't even, we don't even need to go in person, either you or I, for a lot of hearings. Of course, this is different case by case on a case-by-case basis, but we do a lot of travel. I have 3 attorneys on my team besides me, Megan, Christy, and Damian. They're wonderful attorneys, and we all work together on all of our clients' cases. All right. Oh, Ashlyn. Hi, Ashlyn. Ashlyn, we got some good news on your case. My love. I know you got the email. All right. Let's see what other questions I have. All right. How to get your kids if you have no legal status, from Sheikha Williams. Sheikha, I think you're trying to ask like how to file for your kids if you have no legal status. The best thing to do if you have kids who you're trying to help, your kids are undocumented or you're trying to bring them to this country, usually the best thing is we have to see what you can do for yourself first, because a lot of things you can't do for your kids until you do for yourself first. Once you get your status, then you can petition for your kids and help them fix your status as well. So Sheikha, what I would say is the most important thing is to find out what you may be eligible for and then to take action towards getting to those cases. So call us Sheikha 212-248-7907. And hopefully we can do something for you. Santos Rodriguez, I got my I-485 approved. What's next? Congratulations, Santos. That means that you're a green card holder. And what's next? Usually you get your card in the mail. Usually your green card comes within 2 weeks to 30 days after your application's approved. My I-485 is pending for 2 years. I'm married to a citizen. Is this normal from Vic? Vic, no, I wouldn't say that's really normal. Usually to me, that's a sign that they might be setting you up for a fraud interview. And if your marriage is not going well, please call us 212-248-7907. Dave is asking, are immigration officers more harsh on same gender couples for I-485? Dave, absolutely not. Not these days, not anymore, okay? And one more thing I want to share with you is I have been representing lots of couples where one person was formerly married. I have been representing lots of same-sex couples right now in immigration proceedings where one of them may have been married to somebody of the opposite gender previously. So for example, I just had some lovely clients, they're a same-sex couple, and one of them, both are women, and one had been married to a man previously. Not even a question that came up. So if you have been worried about what your, what your sexual identity or your gender identity, all of those things, how it might affect your immigration case, I do want to let you know that it's not a point of concern. And the most important thing is who is the lawyer that's going to be sitting by your side? Who is the law firm that's representing you? Because, you need to have that experience and the guidance to get through these cases properly and with as little amount of fear as possible. Anyway, if you need our help, call us at 212-248-7907. Abhay, hello. Yes, I haven't been online in a long time. I'm trying to get back to it. All right, let's see. If I apply for asylum and then get married, can I travel to my home country on advanced parole? Alex, Gordon, I recommend that you not, because it could call into question as to whether you have filed a fraudulent or frivolous asylum case. Aliman, Mrs. Aliman, I was in a domestic violence situation a while ago. Now I'm married to a citizen. Lawyer telling me U visa. Is there any other way to fix from Aliman? Aliman, if you got married, if you're suffering in your current marriage, then maybe we can help you. The U visa is, probably the best way. We could also see if you are eligible for a T visa. Mrs. Aliman, the best thing to do is to just call us at 212-248-7907. Jocelyn's asking, how long is a VAWA case taking right now? About 2.5 to 3 years. All right. All right, guys, that's John. Thank you so much for the blessings. All right, guys, that's all the time that I have for today. I hope you all have a lovely, lovely day. Keep your heads up high. You're more valuable and more important than you realize. That's the message that I want to give to you today. And I hope you all have a lovely, blessed day.